Okay, I need you to understand something that happened on June 27th, 2025. Something that fundamentally altered how power works in America. Not in some abstract theoretical way, in a way that affects real people, real families, real lives. And I need you to stay with me here because what I'm about to explain sounds technical at first, sounds like legal minutiae that only matters to lawyers and judges. But by the time we're done, you're going to see why this 6-3 Supreme Court decision represents one of the most consequential shifts in constitutional law in modern American history. Picture this. Late morning, Washington, D.C. The Supreme Court releases an opinion in a case called Trump v. Cassa. Most Americans scrolling through their phones that day probably glanced at the headline and moved on. Another Trump case, another legal battle, same old story. But the attorneys reading that opinion in law offices across the country, they froze. Constitutional scholars examining the text, they recognised immediately what had just happened. Because the Supreme Court didn't just decide a case that morning, they rewrote the rules about how Americans can defend their constitutional rights against federal overreach. Here's what the court did. In a 6-3 decision, with Justice Amy Coney Barrett writing for the majority, the Supreme Court held that federal district court judges no longer have the authority to issue what are called nationwide injunctions or universal injunctions. These are court orders that block a federal policy or law from being enforced against everyone in the country, not just the specific people who filed the lawsuit. And for decades, these injunctions have been one of the primary tools that ordinary Americans, advocacy groups, and state governments have used to stop unconstitutional federal actions before they harm millions of people. The court said those injunctions exceed the authority that Congress gave to federal courts. From now on, judges can only issue injunctions that provide what the court called complete relief to the actual plaintiff standing before them in the courtroom. Not to everyone affected by an unconstitutional policy, not to the nation as a whole, just to the people who manage to file a lawsuit and win. Let me tell you why that matters in terms you can feel in your bones. Imagine the federal government announces a policy tomorrow that, let's say, violates the First Amendment. Maybe it restricts certain types of religious worship or limits political speech or targets journalists. Under the old system, if a civil rights organisation or a coalition of states filed a lawsuit challenging that policy and a federal judge agreed it was unconstitutional, that judge could issue a nationwide injunction blocking the policy from being enforced against anyone, anywhere in America. The constitutional violation would be stopped immediately for everyone. That's how it worked. That's how it's worked for years. Under the new system established by Trump v. Cassa, that same judge can only protect the specific people who filed the lawsuit. The civil rights organisation that sued, protected. Their members, protected. But everyone else in America who didn't have the resources, the knowledge, or the legal standing to file their own separate lawsuit, still subject to the unconstitutional policy, still having their constitutional rights violated. The government can keep enforcing the policy against them until they individually sue and win their own case. Do you see the problem? Constitutional rights in America might now depend on whether you live in a state whose Attorney General decides to sue the federal government. Whether you're part of an organisation wealthy enough to file a federal lawsuit. Whether you even know your rights are being violated. Justice Ketanji Brown Jackson, in her dissent, called this an existential threat to the rule of law. She wrote that the court's decision creates what she termed zones of lawlessness, where the executive branch can do whatever it wants to whomever it wants, unless and until each affected individual affirmatively invokes the law's protection. Think about what that means for ordinary Americans, the poor, the uneducated, people who don't have lawyers on speed dial, people who don't even know how to file a federal lawsuit. Under this new regime, their constitutional protections are essentially nullified unless they can navigate the complex, expensive, time-consuming federal court system on their own. Let me give you the context for how we got here, because the case itself involves one of the most inflammatory policy battles in recent American history. On January 20th, 2025, his first day back in office, President Trump signed Executive Order 14160, titled Protecting the Meaning and Value of American Citizenship. This executive order attempted to redefine birthright citizenship under the 14th Amendment. Specifically, it directed all federal agencies to stop recognising US citizenship for children born in the United States if neither parent was a US citizen or lawful permanent resident at the time of birth. This targeted children born to parents who were undocumented, on temporary visas, or in the country on asylum claims. The constitutional provision at issue is crystal clear. The 14th Amendment states, "All persons born or naturalised in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." This has been understood since 1868, when the amendment was ratified, to grant citizenship to virtually everyone born on American soil, with only narrow exceptions for children of foreign diplomats and members of sovereign Indian tribes. The Supreme Court confirmed this understanding in 1898 in United States v. Wong Kim Ark, holding that a child born in San Francisco to Chinese immigrant parents was a US citizen by birth. Trump's executive order flew in the face of 125 years of settled constitutional law, and within days of its announcement, lawsuits erupted across the country. 22 states, led by New Jersey and Washington, filed suits arguing the order violated the Constitution. Immigrant rights organisations, including Cassa de Maryland and the Asylum Seeker Advocacy Project, filed on behalf of pregnant women and hundreds of thousands of members who would be directly affected. Individual plaintiffs, mothers carrying children who would be born stateless under this policy, filed emergency petitions. The lawsuits landed in federal district courts in Maryland, Massachusetts, and Washington state. And here's what happened. 3 separate federal judges, after reviewing the evidence and the law, issued preliminary injunctions blocking Executive Order 14160 from taking effect anywhere in the United States. Judge Deborah Boardman in Maryland, Judge Myung Joon in Massachusetts, Judge John Cockenow in Washington. All 3 concluded that the executive order was, in Judge Cockenow's words, blatantly unconstitutional. All 3 issued nationwide injunctions, protecting not just the named plaintiffs in their courtrooms, but every person in America who would be affected by this policy. The Trump administration appealed, but they didn't appeal the judge's constitutional analysis. They didn't argue that birthright citizenship could actually be limited by executive order. Instead, they focused their entire argument on the scope of the injunctions. They told the appellate courts, and eventually the Supreme Court, that even if the executive order was unconstitutional, the district judges had exceeded their authority by blocking it nationwide. Relief should be limited, they argued, to the specific people who filed lawsuits. The courts of appeals rejected this argument. The Fourth Circuit, the First Circuit, and the Ninth Circuit all upheld the nationwide injunctions. So the Trump administration filed an emergency application with the Supreme Court in March 2025, asking the justices to intervene immediately. The Supreme Court agreed to hear the case on an expedited basis. Oral arguments were held on May 15, 2025, and 6 weeks later, on June 27th, the court issued its ruling. 6 justices sided with the Trump administration. Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. 3 justices dissented: Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson. Justice Barrett's majority opinion is rooted in what's called originalism, a method of constitutional interpretation that looks to historical practice at the time the Constitution was written. Barrett pointed to the Judiciary Act of 1789, the statute that gives federal courts the power to issue injunctions. She argued that this statute only authorises remedies that were traditionally available in English courts of equity in the late 18th century. And according to Barrett's reading of that history, English courts didn't issue universal injunctions. they issued party-specific relief. An injunction could only bind the defendants in the case and could only protect the plaintiffs in the case. Barrett acknowledged that courts need the flexibility to provide complete relief to plaintiffs. But she drew a sharp distinction between complete relief, which protects the parties in the lawsuit, and universal relief, which protects everyone affected by a policy. She wrote that allowing district judges to issue nationwide injunctions would let them end-run the requirements of class action lawsuits under Federal Rule of Civil Procedure 23, which has strict criteria about when a case can proceed as a class action on behalf of a broader group. The dissents were scathing. Justice Sotomayor, writing for herself, Kagan and Jackson, argued that the majority had invented a historical narrative that didn't match reality. She pointed to examples from English equity practice and early American courts where judges did issue broad injunctive relief to prevent ongoing violations of rights. She emphasised that the cases before the court didn't even truly present the question of universal injunctions, because in each case, the district judges had determined that nationwide relief was necessary to provide complete relief to the specific plaintiffs. The states that sued, for example, claimed injury from the fact that some states would recognise birthright citizenship while others wouldn't, creating chaos and confusion. Complete relief for those states required uniform enforcement nationwide. Sotomayor's most pointed criticism focused on the practical consequences. She wrote that the majority's decision renders constitutional guarantees meaningful in name only for any individuals who are not parties to a lawsuit, and provides an open invitation for the government to bypass the Constitution. She warned that the decision could affect not just immigration policy, but any constitutional right. No right is safe in the new legal regime the court creates, she wrote. Today, the threat is to birthright citizenship. Tomorrow, a different administration may try to seize firearms from law-abiding citizens or prevent people of certain faiths from gathering to worship. Justice Jackson filed her own separate dissent, shorter but even more direct. She called the court's decision an existential threat to the rule of law. She wrote that it divides Americans affected by unlawful government action into two groups: those who can afford to sue and win injunctions, and those who cannot. The zone of lawlessness the majority has now authorised, Jackson wrote, will disproportionately impact the poor, the uneducated, and the unpopular. Jackson warned that in this new regime, the Constitution is flipped on its head, for its promises are essentially nullified when the executive can do whatever it wants to whomever it wants, unless and until each affected individual affirmatively invokes the law's protection. Now, let's talk about what this ruling does to the American legal landscape. The statistics tell the story. Federal courts issued only 27 nationwide injunctions during the entire 20th century. But during Trump's first term alone, there were 64. During the Biden administration, 28. And during the first 100 days of Trump's second term, 25. These injunctions covered immigration enforcement, federal employee layoffs, funding freezes, overtime rules, environmental regulations, and election procedures. The Trump administration called this judicial overreach, enabling judge shopping where plaintiffs strategically filed in friendly venues. But supporters argued these injunctions prevented constitutional violations against millions who lacked resources to sue. The Supreme Court sided with the administration, fundamentally shifting the balance of power between executive and judiciary. Here's what it means practically. If a state wins a lawsuit challenging federal policy, the injunction protects only that state's residents. Neighbouring states whose attorneys general didn't sue, still subject to the policy. Individual plaintiffs who win, protected personally, but similar people who didn't sue remain unprotected. The court left three alternative pathways. First, class action lawsuits under Rule 23, though these are complex, expensive and time-consuming. Within hours of Cassa, plaintiffs filed class actions, with Judge Joseph LaPlante certifying a nationwide class on July 10, 2025. Second, challenges under the Administrative Procedure Act, which only applies to agency actions, not presidential orders. Third, state standing, though Justice Alito warned against using this as a loophole. Justice Kavanaugh's concurrence noted that the Supreme Court could still provide uniform interim relief through emergency applications, though critics worry this shifts power to the controversial shadow docket with minimal transparency. The immediate impact is stark. After Cassa, the birthright citizenship order was blocked only in states that sued, leaving parents elsewhere potentially vulnerable until subsequent class certifications provided broader protection. This pattern could repeat across dozens of policies affecting millions. Justice Jackson's warning resonates. Constitutional rights now depend on litigation resources. Immigrants, low-income workers, rural communities, people with disabilities, anyone without immediate access to legal representation faces higher barriers. Geographic inequality emerges too. Your protections depend on whether your state attorney general litigates against federal overreach. Blue state residents might be protected from Republican policies. Red state residents left exposed. The reverse under Democratic administrations. Constitutional rights, supposedly universal, now vary by state borders and political alignment. This could trigger an explosion of duplicative litigation, hundreds of separate lawsuits instead of one nationwide injunction, overwhelming federal courts and creating conflicting rulings until the Supreme Court intervenes. It also dramatically increases state attorneys general power. If 20-plus AGs coordinate, they protect 150 million Americans. But that requires political will, resources, and cross-state alignment, a much higher bar. Healthcare example. Federal rule restricts medical treatments on religious grounds. Under the old system, one nationwide injunction protects everyone. Now, only lawsuit plaintiffs are protected. Other patients, unaware of the rule change or unable to sue, lose access to care. Labour rights. Overtime rules stripped from millions. Unions win injunctions for their members. Non-union workers lose protections until separate lawsuits or class certification, taking months or years. Environmental protections. Federal agency weakens standards. Environmental groups win injunctions for represented communities. Other communities? Exposed to increased pollution. Civil rights. This is most troubling. Constitutional rights should be universal, not contingent on litigation resources or geography. But under Cassa, practical enforcement depends on who can afford lawyers and where they live. The legal landscape will evolve as courts interpret Cassa, Congress potentially responds, and litigants adapt strategies. Some scholars argue complete relief for national organisations or states requires nationwide protection. The APA question remains open. Congress could clarify that unlawful agency actions are vacated nationwide. Congress has options. The House passed the No Rogue Rulings Act, codifying Cassa's limitations. But Congress could authorise nationwide injunctions in specific circumstances, defining standards and procedures. Whether that survives Supreme Court review is uncertain, given Barrett's originalist approach, though her opinion relied on statutory interpretation, not constitutional grounds. Expect massive increases in class action litigation, coordinated multi-state cases, and strategic choices about pursuing class certification over nationwide injunctions. Trump has petitioned the court to rule on birthright citizenship's constitutionality, potentially overturning the 1898 Wong Kim Ark precedent in a separate historic decision affecting millions. So where does that leave us? Here's what you need to take away from this. 1. The Supreme Court has fundamentally changed how Americans can challenge unlawful federal policies. Nationwide injunctions, which for decades were a primary tool for stopping constitutional violations, are now essentially eliminated from the district court level. 2. Constitutional protections may now depend more on where you live, who your state attorney general is, whether you can afford a lawyer, and whether you're part of an organisation that files lawsuits. This creates geographic and economic disparities in how constitutional rights are enforced. 3. The decision affects millions of Americans, even if they don't realise it yet. From immigration to healthcare to labour rights to environmental protection to civil liberties. The inability to obtain nationwide injunctions means that unlawful policies can be enforced against people who aren't parties to lawsuits. 4. There are alternative pathways. Class actions, APA challenges, state standing. But each has limitations and barriers that make broad relief harder to obtain and slower to secure. And 5. This is part of a larger trend in the Supreme Court's jurisprudence, a trend toward limiting judicial power to check the executive branch, toward requiring more formalised procedures for obtaining relief, toward shifting the burden from the government to individual citizens to protect their own constitutional rights. The dissenters in Cassa warned that this decision could create zones of lawlessness, where constitutional violations go unremedied for people who lack the resources to sue. They warned that it invites the executive to violate the Constitution with impunity against anyone who hasn't filed a lawsuit. They warned that it flips the constitutional order on its head, making rights contingent on litigation rather than inherent and universal. The majority responded that they're simply applying the law as it was originally understood, that they're restraining judicial overreach, that the solution to concerns about unprotected individuals is to use class actions and other proper procedures, not to allow single judges to issue nationwide orders. Who's right? That's not a legal question. It's a normative question about how we want our constitutional system to function. Do we want a system where one district judge can block a federal policy nationwide, with all the potential for abuse and inconsistency that entails? Or do we want a system where constitutional protections depend on access to litigation, with all the inequality and injustice that entails? The Supreme Court has chosen the latter, and millions of Americans will live with the consequences. Here's my final thought. Constitutional law isn't abstract. It's not just something that happens in courtrooms and law schools. It's the framework that determines whether your rights are protected or violated, whether you have recourse when the government oversteps, whether justice is accessible or contingent on wealth and power. The Trump v. Cassa decision is a seismic shift in that framework, and the full implications, for better or worse, will unfold over years and decades, touching lives in ways we're only beginning to understand. If this breakdown helped you see past the headlines and understand what's really at stake in this Supreme Court decision, consider subscribing. Because these legal shifts don't happen in isolation. They build on each other, they interact. And staying informed about how constitutional law evolves is the first step to understanding how power works in America and how it affects your life, whether you realise it or not. The Supreme Court has spoken. The question now is how America responds.